My name is Judge Andrew Quee, and at this time, I would note that for those of you joining us from California, you're probably aware that we have rolling blackouts on the forecast this week due to the extreme weather conditions and the wildfires. So, if we do experience a loss of power during today's hearing, we might have to postpone the oral hearing. We probably should be done before 3 o'clock. I think that the greatest risk of power loss is after 3, but if you do lose power or are disconnected and unable to reconnect, I'd ask that you please contact Claudia Lopez to find out what the current status is of the hearing and what you can do from there. With that said, I'd like to welcome everyone to the Office of Tax Appeals. So today's proceedings are being live streamed, and a certified shorthand reporter is going to be transcribing everything that is said today. That transcript will become a part of the public record and will be posted on the website. In response to the COVID-19 state of emergency, this hearing is being conducted electronically with the agreement of all the parties. Because these hearings are being conducted electronically, I'd like to offer just a few reminders to help the process run as smoothly as possible. Please remember to say your name before you speak. This is especially important because some of the participants only have an audio or phone call connection. For that reason, please do not use the chat feature in Webex. And please mute your microphone if you are not speaking to avoid feedback and background noise. If your microphone is muted, you could push the space bar to temporarily unmute it when you want to speak. And also just a reminder that these proceedings are being broadcast live, and any information that you do share on your screen, such as exhibits, are publicly viewable. So with that said, I believe we're ready to go on the record. I'll check with our court reporter. Lynn, are you ready to go on the record? Okay, we're going on the record now. So we're opening the record in the appeal of Michael James Savage. This matter is being held before the Office of Tax Appeals. The case number is 1801-2052, and today's date is Wednesday, August 19th, 2020. The time is approximately 1:00 p.m. This hearing was noticed for Cerritos, California. However, it is being conducted electronically with the agreement of all parties. Today's hearing is being heard by a panel of 3 administrative law judges, myself, Andrew Quee. I will be the lead judge, and Judge Suzanne Brown and Kenny Gast are the other members of this tax panel. All 3 judges will meet after the hearing today and produce a written decision as equal participants. Although the lead judge, myself, will be conducting the hearing, any judge on this panel may ask questions or otherwise participate in today's proceedings to ensure that we have all the information necessary to decide this appeal. For the record, would the parties please state their names and who they represent, starting with the representatives for the taxpayer.
Good afternoon. This is LeVar Taylor, and I'm appearing on behalf of Mr. Savage.
Okay, and do we have another representative for the taxpayer?
Hi, Judge Quee. This is Lisa Nelson, also with the law offices of LeVar Taylor. I am here in support of the taxpayer, although Mr. Taylor, just for efficiency purposes, will be the sole speaker on behalf of the taxpayer.
Okay, thank you. And for the CDTFA, may I ask who's representing CDTFA today?
Chad Backus for the department.
Jason Parker for the department.
Stephen Smith for the department.
Okay, great. Thank you. Again, this is Judge Quee. And so I know we've had 3 pre-hearing conferences on this, so I'll try and make the preliminary matters as brief as possible. I would like to summarize what to make sure we're on the same page. I'd like to summarize everyone's understanding of the hearing today. So I understand that there are no witnesses. The presentations are going to be consisting entirely of oral arguments. As far as exhibits, we have CDTFA exhibits A through D. These were all attached to the minutes and orders, and the appellant has no objections to CDTFA's exhibits. For the taxpayer, I have exhibits numbered 1 through 7. Those were also attached to the minutes and orders, and by minutes and orders, the most recent minutes and orders that we just had after the conference 3 weeks ago. and CDTFA has no objection to these exhibits. I'll start with CDTFA. Is the summary that I just provided correct, CDTFA?
Yes, it is.
Okay, and you have no further exhibits to add, is that correct?
That is correct.
Okay, and for appellant, is the summary that I just provided accurate?
Yes, it is.
Okay, and appellant also has no further exhibits to add?
Correct.
Okay, great, thank you. So those exhibits, exhibits A through D for CDTFA and 1 through 7 for the taxpayer are admitted into the evidentiary record without objection from either party. And I know, having said that, we had 3 hearing conferences. I did have one quick clarification. I understand that the penalties, but not the taxes, are at issue. Is that correct?
That's correct.
Okay.
Even that it's a portion of the penalty, which I will elaborate on.
Okay, yes, and that was just one brief clarification I'd like to ask the parties, because I was unsure of the exact amount that's at issue for the penalties. I can see 2 figures. One is $8,328.28, and the second figure is $8,364.28. So that's a difference of about $36. And I was just wondering if either of the parties can clarify the exact amount at issue, or is that something that they know?
I believe the precise amount at issue, I don't have the number right now. I can go pull it. That we contend was at issue was in our opening brief, our very first brief filed. My memory tells me it's about 11,000, but that I would not rely on my memory, because this is more, the precise amount at issue here is not as important as the legal issue. So I didn't memorize the amount, but I can tell you the periods for which the penalties are at issue.
Okay, great. And I don't want to get too hung up on this, but I guess since you had an opportunity to speak, I'll just quickly ask CDTFA if they know the amount at issue for the penalties.
Chad Backus with CDTFA. Our understanding is that the penalty amount in dispute is $8,328.28. The $11,000 figure that Mr. Taylor stated was the original amount that was contested, but in the Appeals Bureau's supplemental decision dated April 28, 2017, a portion of the original liability period was removed. So the 4th quarter of 2008 was removed. So that reduced, so the penalty amount that was associated with the 4th quarter of 2008 was also removed.
Okay, so CDTFA has 8328.28. Thank you.
Right.
And if either party would like to address that, you could have an opportunity to at the hearing. It doesn't sound like that is the crux of the issue, though. And with that said, just briefly summarize the 2 issues in this appeal. The first, and this was raised by OTA, the first issue is whether OTA has jurisdiction to decide this appeal, because the issue involves the matter of whether the liability of the taxes were discharged in bankruptcy. The second issue is whether appellant's personal liability for the late payment and the late filing penalties incurred by the corporation were discharged in bankruptcy. And that's assuming that CDTFA determines it has jurisdiction to decide this appeal, then that would be the second issue. If we determine we do not have jurisdiction to decide the appeal, then the inquiry would end at the first issue. In either event, there will only be one decision issued for this appeal, though. With that said, we briefly summarized how this case would proceed. Basically, the parties did agree that the taxpayer would have 60 minutes to do their opening presentation to discuss both issues. CDTFA would have 30 minutes to do their opening presentation. And after that, each party would be afforded 5 minutes closing or final remarks. Are there any questions about that, or any, did I state anything incorrectly, or any clarifications that need to be made?
Chad Backus with the department. Sorry, Judge Quee. Just one clarifying question. With the presentations, are we going to present both issues together, or are we going to present first the jurisdiction and exhaust all the questions about the jurisdiction and then move into the second? Just a question of how exactly the format is going to be.
Oh, yes, thank you, Chad. This is Judge Kui. My understanding was that the taxpayer would have 60 minutes, and during that 60 minutes, they would discuss both the first issue and the second issue. And then we return to CDTFA, and then they would address both the first and second. But if the parties would like to split it up half and half, or issue one first, followed by issue two, I'm open to doing that. I'll turn it over to the representative for appellant. Did you have a preference on how we do that?
We have no preference. In fact, I think I'm going to be able to deal with this in less than 60 minutes. And my plan was just to address both issues, answer all questions that the panel members have regarding either issue, either of the two issues, and then let the CDTFA go ahead and have their say. So.
Okay, CDTFA, Mr. Backus, does that sound good with you?
Yes, that's fine. Thank you.
Okay, great. So with that said, I believe we're ready to start the opening presentations. So I will turn it over to the representative for appellant to start their opening presentation. You have 60 minutes. Thank you.
Thank you very much. This is LeVar Taylor appearing on behalf of the appellant. I want to briefly discuss what is at issue, aside from the jurisdictional issue, what precisely is at issue, because it ties into the legal issue that this panel has to decide. Originally, the department or its predecessor had determined that Mr. Savage was personally liable, issued a dual determination under 6829 for a longer period of time than we have at issue now. That was the third quarter of 2007 to the fourth quarter of 2008. Subsequently, there was an agreement between the parties that that period was shortened, and so the fourth quarter of 2008 is what some of the periods are no longer at issue. In addition, for each of the periods which remain, for which the liability was asserted as reduced by agreement of the parties, there are penalties asserted or assessed against the underlying entity, Bella Familia, which are included in the dual determination asserted by the department. Not all of those penalties are at issue. And the reason for that is that for the rules in the bankruptcy code discussing which establish the dischargeability of penalties. So the only quarters for which there is a dispute as to whether or not the penalties were discharged in bankruptcy are the third quarter of 2007, the fourth quarter of 2007, and the first quarter of 2008. The substantive discharge rules in the bankruptcy code are found in section 523A7. That rule is a specific rule designed to deal with tax penalties and tax penalties only. So the rules that govern whether or not taxes are discharged are located in a separate section of the bankruptcy code, 523A1. Section 523A7 has a multi-part test, and it's written, unfortunately, in language that was designed to confuse even the most intelligent person. But the case law that's out there has been out there for a long time. And what that case law says is that you can discharge the penalties if the underlying tax was discharged, the underlying liability, which is not the case here. We're not disputing that the tax portion of the dual determination was discharged. However, there is a separate disjunctive test that, if met, allows the penalties to be discharged. And I'm just going to read the exact language because the exact language is important. That language says that if the penalty is imposed with respect to a transaction or event that occurred before 3 years before the date of the filing of the petition. And so the penalties in this case that relate to the entity bella familia are failure to file on time and failure to pay on time. So for those 3 quarters that are at issue, the third quarter and fourth quarter of 07 and the first quarter of 08, the statutory deadlines to file and pay, which if not met, trigger the running of the penalties, all occurred more than 3 years before the date of Mr. Savage's Chapter 7 bankruptcy. So the latest the latest date we're dealing with is for the first quarter of 08, the deadline, the 3-year period referred to in 523A7 would have run before July of 2011 when the bankruptcy was filed. So that's why we're only dealing with those 3 quarters and why we have conceded that penalties for later quarters are not dischargeable, because the failure to file and the failure to pay by the entity bella familia fell within that 3-year period prior to the date of Mr. Savage's Chapter 7 bankruptcy petition. So the language in 523A7 is very simple. Or I should say the language is not simple, the concept is simple. The concept says if the event or transaction giving rise to the penalty occurred more than 3 years before the date of the bankruptcy, then the penalty is discharged. So why are we arguing over the imposition against Mr. Savage of personal liability for failure to file and failure to pay penalties? Is because the underlying entity failed to file and failed to pay on time, and those events, the failure to file and the failure to pay, all for these 3 quarters, all happened more than 3 years before the date of the bankruptcy. Now the department comes in and says, well, wait a second. The 3-year period, it hasn't been 3 years since we asserted a dual determination. We don't, the dual determination was not asserted and more than 3 years before the date of the bankruptcy, a point which we don't dispute, but from our standpoint, that's legally irrelevant. The penalty is not imposed, it's imposed because of the corporation's failure to file on time and failure to pay on time, not because of something Mr. Savage did. Now, to give an example of a different kind of penalty where the analysis would be different, is that if there's a dual determination under 6829 and that dual determination is sustained or agreed to by the taxpayer, and the amount that's paid, the amount that for which that person is liable or they're assessed is not paid within a period of time, there's a separate finality penalty that's assessed against that person. That particular penalty is assessed because of the failure of the person who was assessed to pay that penalty. So that's a separate analysis. It is different from the analysis of whether the penalties that form the basis of the asserted 6028-9 assessment occurred more than, the penalties are based on transactions or events occurring more than 3 years before the date of the bankruptcy. So so that's the legal analysis. I'd like to step back for a moment and explain why we brought this case over what is now an $8,000 penalty. Many years ago, I raised this same issue in a case that's reported in the Ninth Circuit called Daniel Ilko. In that case, we argued a number of things. In that case originally was brought before this tribunal's predecessor, the Board of Equalization, administratively. And then after Mr. Ilko did not prevail there, he went and filed an action in the bankruptcy court to determine whether or not the asserted 6829 liability was discharged. At the trial level of that case, the department's predecessor agreed on facts that are indistinguishable from the facts of the present case for purposes of that issue, that the personal liability for the penalties against resulting from the underlying entity's failure to file and failure to pay on time were dischargeable, even though the bankruptcy was filed before there was an assertion of dual liability. In other words, you look to say, why are these penalties here? Well, they're here because the underlying entity didn't file on time and didn't pay on time, and the department or the Board of Equalization at the trial level in the bankruptcy court agreed with that analysis and ceded. Then the other issues in the case were decided. They were decided in Mr. Ilko's favor in the bankruptcy court, and the board appealed to the Ninth Circuit, and they prevailed on those other issues. So the Ilko case, it doesn't deal with the issue we have here directly, at least not the reported decision, but there was action taken, or I should say, by the California Attorney General's office to agree with our position. And one of the reasons we're here, probably the key reason, is that we're requesting this tribunal to issue a ruling on this, because what we don't want to have happen is when taxpayers go or are faced with this issue, taxpayers who really don't have a lot of money are faced with this issue, they don't have to go to bankruptcy court and then have the Attorney General's office likely concede, as they did in Ilko. We want a ruling out there that tells people, hey, look, department, you can't do this because the bankruptcy code says you can't. So that's why, in the bigger picture, why we're here today. I'd like to talk, and so if the members have questions about the legal argument before I go on to jurisdiction, I've actually done what I could to shorten this for the benefit of everybody. And that is the short version of my argument on the legal issue that does of whether or not the taxes, whether or not the penalties were discharged in Mr. Savage's Chapter 7. I'm happy to answer any questions on that legal issue that the members of the panel have, or if you prefer, I'll just go ahead and dig right into the jurisdictional issue.
Mr. Taylor, this is Judge Quee. I just had one quick clarification. Which prong under 507A8A were you saying that were you providing the analysis for with respect to the penalties and the 3 years?
This is Mr. Taylor again. It's not 507. It's 523A7. 507. So if you look at the analysis of the bankruptcy code, 523A1 deals with the dischargeability of taxes. That section references 507A8. And just say, generally speaking, the first rule under 523 says if a tax is entitled to priority, it's not dischargeable. Okay, there's other tests there, but so 523A1 references 507A8 for the tax and just the tax. 523A7 deals with penalties, a completely different analysis. And so the specific subsection is 523 A7B is in boy. It says impose with respect to a transaction or event that occurred before 3 years before the date of the filing of the petition.
Okay, thank you.
Okay. Any further questions before I address jurisdiction?
If there's no further questions from the panel, you may please proceed.
Thank you. This is Mr. Taylor again. The jurisdictional issue is one that I was stumped, frankly, because when the panel asked it, which, I mean, every tribunal needs to find out to decide if they have jurisdiction. It's an important issue. We were not able to find any precedential opinion that deals with whether or not the board, this tribunal or this tribunal's predecessor has the jurisdiction to determine the dischargeability of sales and use tax issues or liabilities or dual liabilities under 6829. There is a rule out there cited in our brief that says that this tribunal lacks jurisdiction to determine the dischargeability of income taxes that are asserted. And so that makes sense when you consider how those income tax cases got to the Board of Equalization and how they now get to the Office of Tax Appeals. So what happens when the Franchise Tax Board audits, they audit an income tax return, and if there's no agreement, then they issue a notice of proposed assessment. That notice of proposed assessment says, we think you owe some additional taxes and maybe some penalties to go with it. And that appeal goes forward, and within the Franchise Tax Board itself, they do not consider whether or not the taxes or even the penalties are dischargeable. I mean, I've handled income tax cases where we believed the penalties were dischargeable and the taxes were not because of a prior bankruptcy. And well, Franchise Tax Board in their internal administrative appellate procedure at the protest hearing, they didn't consider that. And then when they issue their notice of action, which is what triggers the jurisdiction of either the old Board of Equalization or the Office of Tax Appeals, when they issue that notice of action does not address the question of dischargeability of either the asserted tax, the disputed tax, or the disputed penalties. So when that case comes to this tribunal or its predecessor, that issue has never been discussed by the agency itself. And so I can understand why there would have been a rule, and still is a rule out there, that says, well, we're not going to consider the dischargeability of asserted income tax deficiencies or penalties on asserted income tax deficiencies. Now, when you back up now, and let's look at what happened, and it happened under the with the Board of Equalization, and the board, and I'm talking now about the agency conducting an audit or deciding whether to assert a dual determination under 6829. I have not just, I did this in the ILCO case, although, again, unfortunately, because the case is so old and my files are destroyed, I don't recall whether the Board of Equalization considered the issue in its ruling, but we raised the issue of the dischargeability of the asserted dual liability in Mr. Ilko's case. And we raised the dischargeability of the asserted penalties in Mr. Savage's administrative appeal. And there is an exhibit in this case, the decision and recommendation issued under before the transition to the Office of Tax Appeals, which addresses in quite a bit of detail the question of whether or not the penalties were discharged. So what happened is that in the Board of Equalization, the agency actually considers the issue. And they write up, in this case, they wrote up a decision and recommendation which addressed the issue. And so when the issue then comes to this tribunal, it comes in a manner in which the agency itself has considered it and has ruled on it, where there is not only just a live dispute, but actually the agency itself has taken the time to say, okay, here, Mr. Savage, we've looked at your argument, we don't like it, okay? If you don't like our answer, previously it was go to the Board of Equalization. Now the answer is, let's go to the Office of Tax Appeals. So there are no rules out there that say that cannot happen. I've looked for them, I cannot find them. I've looked for cases that say, what can that happen or can it not happen? I have not, in both administrative rulings and court cases. I've not found any cases that address this specific point. However, just as a matter of logic, in the absence of some statute or rule that says this tribunal cannot consider it, if the agency itself deems it appropriate to consider that issue, which they did in this case, it is entirely appropriate for this tribunal to consider that issue in this appeal rather than dismiss it for lack of jurisdiction. So If they're, and so that's the short version of my argument on the jurisdiction. I'm certainly willing to answer any questions that the members of the panel have.
This is Judge Quigan, and thank you. And I would just briefly like to go back to the substantive argument, if you don't mind. Just wanted to get a quick clarification on that, just to make sure I'm understanding the taxpayer's position. So I understand that you're not disputing that the taxes are not discharged. And just, I guess I'm trying to distinguish why the taxes are being treated differently from interest or penalties, because you're only disputing the penalties from my understanding. And so just to clarify, do you agree that the taxes are accepted from discharge under 507A8 but then there's a separate analysis for the penalties on those taxes? Is that the crux of your argument?
This is Mr. Taylor again, and the short answer is yes, and I would like to elaborate and explain. Again, the dischargeability of taxes is dealt with by 507A1. And the issue of whether or not the taxes were discharged is the precise issue litigated in ILCO. And so, I'm not going to sit here and argue that the Ninth Circuit was wrong, okay? I think they were wrong. I don't agree with them, but the specific test which was addressed in the ILCO case was whether or not the taxes were assessable, unassessed but assessable. Okay, and that's a separate test in 523A1, which incorporates 507A8. Okay, so again, these are really two separate statutory regimes. And so in 523A7, which deals with penalties, doesn't deal with whether or not the taxes are assessed or whether the penalties are assessed or unassessed. I've had multiple agencies, not, the IRS, Franchise Tax Board, Employment Development Department, and other agencies agree that even though the taxes were not assessed against my client, because the transaction giving rise to the penalties occurred more than 3 years before the date of the bankruptcy, that the penalty was discharged. So, I mean, I haven't even had to litigate this issue against the Franchise Tax Board because they just agree. They look at it and they say, oh, okay, we see. And the Ninth Circuit case, it's perhaps useful to discuss the facts in the Ninth Circuit case that we rely on, that everybody agrees governs this. And in that case, the taxpayer pled guilty to tax evasion under 7201. They said, we filed a fraudulent return. And because they filed a fraudulent return, the tax could not be discharged. That's clear cut. But the Ninth Circuit said, well, the penalties are discussed under a different rule, the fraud penalties. And why were the fraud penalties imposed? Well, because the debtor taxpayer filed a fraudulent return. And so even though the taxes were not assessed because there was a criminal prosecution and the civil audit is delayed until after the criminal prosecution, and so it was many, many years later that the IRS finally assessed the tax. Okay. Notwithstanding that fact, the Ninth Circuit said, well, look, the fraudulent return was filed more than 3 years before the date of the bankruptcy. So and under that analysis, the penalties are discharged. So there are two very distinct tests. They are independent of one another, although they are linked in this way, in that if the tax is dischargeable, the penalty is dischargeable. But again, there's a separate disjunctive test that says if the transaction or event on which which generated the penalty occurred more than 3 years before the date of the bankruptcy, then the penalty itself is discharged, even though the tax is not.
Thank you. This is Judge Queen. I did have one additional question on that, and that's getting to, I guess, the assessable but not yet assessed language with respect to the taxes. And because 6829 cases, there are dual determinations. I understand the corporation gets the penalty, say, in year one, but then if the corporation is still operating, there's no basis for the taxpayer, the responsible person, to be held liable for that penalty. So I'm just wondering, so assuming we're to say that these are two separate tests, if we agree there's jurisdiction, we agree there's two separate tests for taxes and penalties, I'm just wondering if 6829 dual determinations are a unique scenario in that that determination doesn't get issued until after there's a termination of the corporation. So, I mean, why isn't the termination of the corporation basically, that or a determining factor or relevant factor? Because how could you say it was assessed? Or how could you say the actions occurred when the taxpayer didn't even have a liability for the penalties at the time that they were imposed on the corporation? Because it's the dual determination that imposes the liability on the corporation. It's not, and in this case, it's not even yet final because it's a petition, is my understanding.
Because of the language of the statute, which I will read again. And it says, imposed with respect to a transaction or event. That is, the penalty is imposed. Okay, not the tax. The penalty is imposed with respect to a transaction or event that occurred more than 3 years before the date of the bankruptcy. So the question is, if I may take the liberty of rephrasing it, is that why was the penalty imposed? The penalty was imposed because the underlying business entity didn't file on time and didn't pay on time. And again, I distinguish the penalty that's imposed on the responsible person under 6829. If there is a final assessment and they don't pay on time, they get hit with a finality penalty. And that penalty is based on a separate event, the failure to pay on time, and you would have to start a new 3-year period that runs from that failure to pay the separate assessment. Section 523A7 doesn't reference assessment. It just says if the transaction or event giving rise to the penalty happened more than 3 years before the bankruptcy petition, well, then the penalty is discharged. So the reason, to answer your question, Judge Quee, is it's the language of the statute.
Okay, thank you. I'll turn it over to the panel to see if they have any additional questions to ask. I'll start with Judge Brown. Judge Brown, do you have any questions?
This is Judge Brown. I think I just have one question for the appellant. In reading the briefing you've submitted, it seems that you seem to be relying a lot on the facts of ILCO, meaning the fact that CDTFA conceded the penalties in that case. I want to make sure I understand your argument. You're not saying that because CDTFA made a concession in this different case that's legally, a precedent for us to consider, or are you?
This is Mr. Taylor again, and the answer is no. We're not arguing it's not binding. There's no estoppel, but they got it right back then. That's what we're saying, and we're pointing out the kind of the horizontal inequity of taking different positions. And look, they can take it, they can do it. There's no law that says they can't. I want to make that clear. But they did get it right back then in ILCO when they conceded.
This is Judge Brown. Thank you. I guess I just want to clarify. I looked through all the submissions. I don't see anything in the evidence establishing the basis for why CDTFA conceded back in the ILCO case. Is that correct? I just want to make sure I'm not missing anything.
No, the only thing that's in the record is the pleadings at the bankruptcy court level. I mean, nobody shared with me in a forum that I can present to this court or this tribunal any information regarding why they conceded. They just agreed that I was told by the Deputy Assistant Attorney General who handled the case, who's now deceased, that they agreed with my analysis and they were giving up. That was great. But again, I'm not arguing that's binding on them here.
This is Judge Brown. Okay, thank you. That was all my questions for now.
This is Judge Quee. One additional question came up, and I'm just wondering, supposing OTA were to conclude that we lack jurisdiction, is it possible for appellant to file an adversary complaint to seek a determination from the bankruptcy court whether or not this liability was discharged? I'm wondering if there are other remedies in the event that we were to conclude we lack jurisdiction.
It is possible for Mr. Savage to go back in and reopen this. Yes, it is. I mean, that fact, however, doesn't preclude, but the mere fact that other courts like the bankruptcy court have jurisdiction doesn't preclude this tribunal from exercising jurisdiction. There's a provision in the California Government Code that I have. It's cited in the briefs. I can't remember the code section, but it's a very, very short provision. And it says that the Office of Tax Appeals will not be treated as a tax court. I don't know what that means. I do know, however, that the mere fact that a court or a tribunal has the ability to consider the dischargeability of the penalties in this case doesn't mean that that tribunal is a tax court. Otherwise, the bankruptcy court would be a tax court. And otherwise, the Superior Court would be a tax court. And of course, the Superior Court, you have to pay first and file a refund claim. And that's not going to happen in this case with Mr. Savage. He doesn't have any money. So just because, and again, I don't know what that means. It's very, but we know that the bankruptcy court is not a tax court just because it can consider dischargeability issues.
Okay, this is Judge Queet. Thank you very much. And I'll turn it over to Judge Gast. Judge Gast, do you have any questions?
This is Judge Gast. I don't have any questions at this time. Thank you.
Okay, back to Judge Queet. At this time, I'll turn it over to CDTFA to do their opening presentation. CDTFA, you have 30 minutes. Thank you.
Thank you. This is Chad Backus for the department. This appeal involves appellant's personal liability for the unpaid tax liabilities of Bella Famiglia Incorporated for the period July 1st, 2007 through December 14th, 2009. In its decision and recommendation dated December 30th, 2015, the Appeals Bureau found that appellant was not personally liable for Bella's tax liabilities for the period January 1st, 2009 through December 14th, 2009. Appellant is no longer contesting whether he is personally liable for Bella's tax liabilities for the period July 1st, 2007 through December 31st, 2008. Instead, appellant is asserting that he is not liable for the penalties imposed on Bella, totaling $8,328.28. Pursuant to Title 28 of the United States Code, Section 1334, bankruptcy courts have either exclusive or concurrent jurisdiction over all cases under the Bankruptcy Code. In the case of In re Aldrich, the bankruptcy court found that bankruptcy courts have exclusive jurisdiction to determine whether a debt is discharged under Section 523, Subdivision A2, 4, and 6 of the Bankruptcy Code. The court also found that for all other subsections of Section 523, Subdivision A, bankruptcy courts and state courts have concurrent jurisdiction to adjudicate whether a debt is discharged. Pursuant to California Government Code Section 15672, the Office of Tax Appeals shall not be construed to be a tax court. Here, appellant contends that the penalties at issue were discharged in its bankruptcy proceedings pursuant to Section 523, Subdivision A7 of the Bankruptcy Code, of which bankruptcy courts and state courts have concurrent jurisdiction. Because the Office of Tax Appeals is neither a bankruptcy court nor a state court, it does not have jurisdiction to determine whether the penalties were discharged. We acknowledge that appellant's bankruptcy case is now closed. However, the bankruptcy court in Kohler versus Grant held that a matter over which a bankruptcy court has jurisdiction can be considered by that court even if the case is closed. Additionally, in Staffer versus Predovich, the Ninth Circuit held that a separate motion to reopen a bankruptcy case is not necessary when commencing an action for non-dischargeability of a debt under Section 523, Subdivision A3, capital B, and that the debtor need only to file a complaint to determine non-dischargeability with the bankruptcy court. Therefore, appellant's appropriate course of action is to either file a complaint to determine non-dischargeability with the bankruptcy court or to open a case in state court. I wanted to address the issue of the predecessor, the Board of Equalization, the predecessor to the CDTFA and also to the Office of Tax Appeals, and why they heard matters and decided matters of dischargeability, and why the Appeals Bureau makes determinations on dischargeability of debts. When CDTFA was the Board of Equalization, the appeals process for a taxpayer to appeal an adverse determination went through the Appeals Bureau. The Appeals Bureau would write a decision and recommendation, which essentially was a recommendation to the members of the board who were going to hear the case of how the Appeals Bureau, how the legal department believed that the case should be decided. And ultimately, the members of the board decided if they were going to follow that recommendation or if they were not going to follow it. And they made the final determination. And at that point, the determination of the agency, Board of Equalization, was complete. And so a taxpayer in that case, if the Board of Equalization decided that a tax debt was not discharged, then the taxpayer could then take that and either file a motion in state court or go back to the bankruptcy court and say, we think they're wrong and we need a decision made on whether the Board of Equalization was correct or incorrect in determining that the debt was not discharged. Now, with the creation of the Office of Tax Appeals, that process at the CDTFA now ends once the Appeals Bureau writes their decision. It's no longer a decision and recommendation. It is a decision, and that's the final decision of the agency. So now that the agency has decided, based on the Appeals Bureau decision, that the penalties were not discharged, that determination has ended. There's no second step. The Office of Tax Appeals now decides whether, in most cases, that where the Office of Tax Appeals has jurisdiction, the Office of Tax Appeals acts as the board used to act with the Franchise Tax Board. So that the Franchise Tax Board, they make their final determination and it went to the Board of Equalization for their review. And now the Office of Tax Appeals acts in that capacity for both the Franchise Tax Board and the California Department of Tax and Fee Administration. So that's the distinction that we see with why things have changed. There is no rule that says that the California Department of Tax and Fee Administration cannot look at dischargeability, because if a taxpayer is asking or claiming that a debt has been discharged in bankruptcy, then the department will consider it. That's what the department does. That's what the Appeals Bureau does. As far as again, for the department, our determination has been made, and taxpayer then now can take that, and if they disagree, their course of action is to take that back to the bankruptcy court and file a motion, or file a complaint, or to open a case in state court. Based on the foregoing, the Office of Tax Appeals does not have jurisdiction to determine whether the penalties at issue have been discharged in appellant's bankruptcy proceedings. Because appellant has conceded all other aspects of his appeal, including those properly within the jurisdiction of the Office of Tax Appeals, this appeal must be dismissed. One final note about, sorry, things keep slipping my mind, but one final note about that is the never mind. I can't think of what I was going to say, so I'll move on. Moving on to whether the penalties were discharged in the bankruptcy, the remaining dispute, it's based in fact, and there's not really any dispute. Both parties agree that the applicable law is Bankruptcy Code Section 523, Subdivision A7, capital B, which states that any tax penalty imposed with respect to a transaction or event that occurred 3 years before a bankruptcy petition is filed may be accepted from a Chapter 7 discharge. Moreover, the parties agree that McKay versus United States correctly interprets Section 523A7, capital B. In McKay, the Ninth Circuit Court of Appeals states, and I quote, Section 523, Subdivision A7, capital B is quite straightforward. It makes dischargeable any tax penalty imposed with respect to a transaction or event that occurred before 3 years before the date of the filing of the petition. A penalty imposed on unpaid taxes accruing more than 3 years before the filing of the bankruptcy petition is dischargeable, close quote. Therefore, the only remaining dispute concerns the date of the transaction or event giving rise to the penalty. Bella originally incurred the penalties at issue when it failed to file its sales and use tax returns for the third and fourth quarter of 2007 and the first and third quarter of 2008. Appellant filed his Chapter 7 bankruptcy petition on August 31st, 2011. On February 26th, 2010, the department became aware that Bella ceased business operations. Therefore, as of February 26, 2010, appellant became personally liable for Bella's unpaid tax, interest, and penalties if the department could prove all elements of Revenue and Taxation Code Section 6829. It is important to note that appellant does not dispute that he is personally liable for Bella's unpaid tax liabilities. Accordingly, pursuant to Section 6829, Subdivision A, that is from the Revenue and Taxation Code, appellant is also personally liable for penalties incurred by Bella. Section 6829 is a derivative statute, meaning that the tax liabilities and penalties incurred by Bella are being passed through to appellant as an individual. This distinction is critical in determining the event or transaction date, because while Bella incurred the penalties when it failed to file its sales and use tax returns, appellant did not incur personal liability for the penalties until he became personally liable for Bella's unpaid liabilities, when the department became aware that Bella ceased business operations, which occurred on February 26, 2010. Because appellant filed his Chapter 7 bankruptcy on August 31st, 2011, the February 26, 2010 transaction or event date did not occur more than 3 years prior to the filing of appellant's bankruptcy. Thus, the penalties were not discharged in an appellant's bankruptcy matter. I am available for questions if you have any. Thank you.
Yes, thank you. This is Judge Kui, and I guess I would like to follow up on that last part on the 523 A7 B that you were just referring to, where it's talking about what's not accepted or what would be accepted from discharge and what would not be accepted from discharge. And then there's the language of with respect to a transaction or event that occurred before 3 years before the date of the petition. So my understanding is CDTFA was saying that if that transaction occurred, and in this case, CDTFA is saying the transaction was discovery and that termination, but if that transaction occurred more than 3 years, then it would be dischargeable. But if it occurred within 3 years of the petition, then it would not be dischargeable. Is that what CDTFA is saying?
Correct. If the transaction or event date occurred, sorry, this is Chad Backus with the department. If the transaction or event date occurred more than 3 years prior to the filing of the bankruptcy petition, then those penalties would be discharged.
Okay, this is Judge Kui again, and thank you. And I just have another clarification on that because You know, 523A starts off by saying that discharge it does not apply to, and then when you get down to 7, it has A or B, and you're talking about B, but then another thing which would be not discharged is subdivision A7A, and that is relating to a tax of a kind not specified in paragraph 1 of this subsection. And I'm wondering, the CDTFA have a position on whether that could be applicable here or whether that's applicable here?
I don't have it. I don't have that subsection open in front of me, and I, at this point, do not have a position. But we can look into it after the hearing if you would like.
Okay. I'll turn it over to the representative for appellant just to see if they would like to offer an opinion on that. Mr. Taylor?
I'm sorry?
This is Judge Quee. I was just turning it over to appellant to see if they would like to offer an opinion on whether or not sub 523 11 USC 523A7A would be applicable, or if
Okay, this is Mr. Taylor again. And so that subsection relates, that basically says that if the tax is discharged, okay, if it's not accepted for discharge under 523A1, the penalty is discharged. That's what it says. So here, we're not arguing that the tax was discharged. So we're not arguing that it's the penalty is dischargeable under A7A. So when you look at it, it's a triple negative, which can be confusing. But it basically says if the tax is discharged, the penalty is discharged under that section. But because 507A or 523A7A and 523A7B are disjunctive, you can satisfy either test, either rule, and discharge the penalty.
Okay, I think I see what you're saying. I'll turn it over to the panelists at this time. Judge Brown, do you have questions for either party?
This is Judge Brown. I do not have any questions.
Okay, thank you. Judge Gast, do you have questions for either party at this time?
This is Judge Gast. I had a quick question for Mr. Backus. The BOE, from my understanding, wasn't a tax court either. So can you clarify one more time why the BOE was allowed to consider discharge?
I'm sorry, this is Judge Quee. Judge Gast, we're not able to hear you. Yeah, I think you need to get a little closer to your mic. Would you please repeat?
Can you hear me now?
Yes, thank you.
Okay, sorry about that. I had a question for Mr. Backus. You had said that the BOE did discharge or consider dischargeability prior to the OTA being established. My understanding is the BOE wasn't a tax court either. So can you address that one more time for me?
Sure. This is Chad Backus with the department. What I was trying to convey is that the Board of Equalization, or the members of the Board of Equalization that would conduct similar types of hearings, they acted on behalf of the agency. So yet it's true they were not a tax court either, but they were making a final determination on behalf of the agency, in the same way that the Franchise Tax Board would make a determination based on for the agency or the EDD or any other agency that might have that a taxpayer might have a debt with, that the taxpayer might believe that debt is discharged. When a taxpayer gets a discharge order in a bankruptcy case, then they go to the agency where they have debts and they seek to have their debt discharged by the agency. The agency has to determine if they are going to discharge the debt or if they are not going to discharge the debt. And if they don't, there has to be a final determination for then the taxpayer to go back to the bankruptcy court or to the court and say, we think they're wrong. And so that's essentially what I'm saying is the Board of Equalization, the board members were able to, part of their function was to make a final determination on behalf of the agency. That's what they did. And it wasn't until they made that determination that then the agency would go and try to collect whatever liabilities were owed.
This is Judge Gast. Thank you for your explanation. I don't have any further questions.
Okay, this is Judge Quay. At this time, I'm going to turn it over to the parties to have their 5 minutes on closing remarks. I'll start with the taxpayer. Mr. Taylor, you have 5 minutes for any final closing remarks.
Thank you. This is Mr. Taylor again. I want to point out that with respect to the jurisdictional issue, this case is a transitional case. So the appeal was filed and pending with the Board of Equalization when the OTA was created. I'm probably the person with the least amount of knowledge on this call as to the scope of the OTA's authority with respect to cases inherited from the Board of Equalization. I'm sure members of the panel have dealt with that and staff members have dealt with that far more often than I have. However, I'm not aware of anything in the statutory scheme that created the Office of Tax Appeals that says that with respect to an item that was pending at the time before the Board of Equalization, we're going to strip the OTA of authority to hear the case. So maybe, and I don't know, this panel doesn't have to address that necessarily, maybe there's a distinction here between cases that were pending on the discharge versus cases that were not. Because I don't think the California legislature intended to strip the OTA of powers that were held by the Board of Equalization at the time the law was enacted. And clearly, everybody agrees that the Board of Equalization now, at least what I hear Mr. Bacchus say, yeah, they did determine it. They have the authority to determine it. So, again, I'm not the person most knowledgeable on that issue, but I'm certainly not aware of any statutory authority that says that this tribunal is being stripped of the authority to decide something that the Board of Equalization had the authority to decide at the time the Office of Tax Appeals was created. With respect to the merits, I asked the members of this tribunal, take a look at the language. The language says, imposed with respect to a transaction or event. The penalty is imposed. Okay? All right? The penalty is imposed with respect to a transaction or event. Not personal liability for a penalty, but is the penalty imposed? The language focuses on the penalty, not the personal liability for the penalty. And there's no doubt whatsoever that the penalty was imposed with respect to a failure to pay and a failure to file that occurred more than 3 years before the date of Mr. Savage's bankruptcy petition. Thank you very much.
Yes, thank you. This is Judge Quay. At this time, I'll turn over to CDTFA, Mr. Bacchus, for your final comments.
Thank you, Chad Bacchus for the department. Just to respond and to kind of continue to try to clarify the change that happened when the legislature created the Office of Tax Appeals. At that point in time, whatever appeals were pending before the Board of Equalization, at that time, when it got switched over, the department's or the agency's final determination became the decision that was written by the Appeals Bureau. And I want to point out that when the Office of Tax Appeals was created, they had emergency regulations in place. And one of the emergency regulations stated that the Office of Tax Appeals did not have jurisdiction to hear bankruptcy cases, cases involving discharge and bankruptcy. And that regulation changed but now there are proposed amendments to the regulations that add that limit to the Office of Tax Appeals jurisdiction back. And so once those proposed amendments are accepted, the Office of Tax Appeals will again not have jurisdiction to hear cases involving discharge and bankruptcy. Moving on to the transaction or event date, again, there's a distinction in 6829 cases. 6829 is a derivative statute. There is a distinction between the penalties owed by the underlying business entity, in this case, Bella. They owed tax, and the penalties were imposed upon them for their failure to file the returns. However, the penalties passed through and imposed on Mr. Savage it's the same penalty because it's passed through, but his liability for that penalty did not occur until the business entity ceased business operations. It wasn't until that time that he could even be held liable for the tax or penalties. So a distinction has to be made, and it was at that distinction in that is at the crux of this appeal. That's when Mr. Savage became liable for the penalties at issue. Thank you.
This is Judge Kui. I think we lost a representative for appellate. Was it Lisa Nelson? I think she dropped off at the beginning of CDTFA's closing remarks. I just noting that for the record, and I'm confirming with appellant's remaining rep, Mr. Taylor. Do you have any objections to continuing to proceed in absence of your other representative?
This is Mr. Taylor again. No objection whatsoever to this matter proceeding. Thank you.
Okay, thank you. This is Judge Kui. Then, Mr. Backus, were you finished with your presentation?
Yes, I am. Thank you.
Okay, thank you. This is Judge Kui. Then I'll turn it over to the panel to see if the panel would like to ask any final questions at this point. I'll start with Judge Brown. Judge Brown, do you have anything further to ask?
I don't have any. This is Judge Brown. No, I don't have anything further. Thank you.
Judge Gast, do you have any further questions before we conclude today?
This is Judge Gass. I don't have any further questions. Thank you.
Okay, then this is Judge Kui. We're ready to conclude today's hearing. This case is going to be submitted today, August 19th, 2020, at approximately 2:06 p.m. Thank you, everyone, for coming in today. The record in this appeal is now closed. The judges are going to meet and decide your case later on, and we'll send a written opinion of our decision within 100 days from today. The hearings for today are now adjourned, and thank you. Thank you, everyone.
Thank you.